The congressional hearing room grew quiet as Mark Levin, a well-known conservative radio host recognized for his strong voice and firm constitutional views, leaned toward his microphone. His eyes fixed on Representative Jasmine Crockett across the chamber. What happened in the next half-minute would soon spread widely online, leaving many asking whether the veteran commentator had just been challenged effectively by a first-term congresswoman. Before examining the exchange, viewers were encouraged to stay engaged, as the moment reflected a rare and direct political confrontation. This was not a routine hearing. It brought together two legal minds from very different paths, one long established, the other still building a national profile. By the end, perceptions on both sides would begin to shift. Tension had been building ahead of the session. Mark Levin, often praised in conservative circles, had been invited to testify before the House Judiciary Committee on matters related to constitutional interpretation and executive authority. Over the years, he had built a reputation through his broadcasts, books, and commentary, becoming a prominent voice in conservative legal thought. His audience viewed him as a confident and influential figure in political analysis. Across from him sat Jasmine Crockett, representing Texas's 30th District. At first glance, she appeared to be an unlikely challenger, relatively new to Congress and without the same level of national recognition. However, her calm demeanor reflected a strong legal background developed through years of courtroom experience. She had handled cases where outcomes directly affected people's lives, sharpening both her knowledge and her focus. The hearing was expected to follow a familiar pattern. Levin would present his views, respond to supportive questions, and address criticism from opposing members. It seemed likely he would leave with another widely shared moment reinforcing his perspective. Yet, as Crockett adjusted her microphone and met his gaze, the atmosphere suggested something different was about to unfold. "Mr. Levin," Crockett began in a steady and measured tone, "before we begin, I'd like to clarify your background. You've written extensively on constitutional law, correct?" Levin responded with a confident expression, similar to the one often heard in his broadcasts. At that moment, it was not yet clear how significant the exchange would become. Understanding the weight of this interaction requires context about both individuals. Mark Levin is not simply a commentator. With a law degree, experience in government service, and best-selling books such as Liberty and Tyranny and American Marxism, he has built a strong reputation within conservative circles. His program reaches a wide audience, where he regularly discusses legal and political issues with certainty and clarity. His style often includes sharp critiques of opposing viewpoints, which many of his listeners appreciate. At the same time, Jasmine Crockett brought a different kind of experience. Before entering politics, she worked as a civil rights attorney and public defender. She handled cases that required practical application of the law in real-world situations. A graduate of the University of Houston Law Center, she developed her skills through direct legal practice rather than commentary alone. In preparation for the hearing, Crockett had carefully reviewed Levin's past statements and debate style. Her team examined how he approached disagreements and how he framed arguments about legal authority. She entered the room ready, with a clear understanding of both the subject matter and the person she would be questioning. The stakes extended beyond a single exchange. The discussion reflected broader questions about who shapes constitutional interpretation in modern political discourse. It also highlighted the contrast between established voices and emerging perspectives, as well as the balance between theoretical argument and practical legal experience. Levin approached the hearing as an opportunity to reinforce his long-held views on constitutional principles. However, he was now engaging with someone whose experience came from active legal work in courtrooms, where decisions carry immediate and serious consequences. That difference would shape the tone and direction of what followed. The hearing room was filled and C-SPAN cameras were broadcasting live. Conservative media expected sharp sound bites showing Levin in a strong position, while progressive outlets looked for a different outcome. Online interest was already growing. The phrase "Levin versus Crockett" was trending even before the first question was asked. Behind Levin sat a full team of aides and researchers, equipped with binders of constitutional material. Behind Crockett sat a single aide with an iPad. She appeared comfortable relying on her preparation and first-hand legal experience. The opening portion of the hearing unfolded much as Levin had anticipated. He spoke with confidence about constitutional originalism, referencing the Federalist Papers and mentioning the Founding Fathers with familiarity. Republican members posed supportive questions, and he delivered structured, camera-ready responses similar to those heard on his program. Then it was Crockett's turn. "Mr. Levin," she began, her tone professional with a slight firmness, You've been very vocal about the quality of legal education in this country. On your show last month, you said, and I quote, "Half these Democrats couldn't pass a first-year constitutional law exam if their life depended on it." Do you recall saying that? Levin adjusted his glasses, a gesture often associated with preparing a response. "I say many things on my show, Congresswoman," he replied. "But yes, I stand by the view that many politicians today lack a strong understanding of the Constitution." "I see," Crockett continued, briefly glancing at her notes. "And you've also said that some law schools are, in your words, degree mills that hand out participation trophies instead of providing a serious education. Do you still believe that?" The room grew more tense. Even some Republican members shifted slightly, sensing a more pointed line of questioning. Levin's tone became firmer. "Yes. The decline in legal education is real. When schools prioritize factors other than academic rigor, and when graduates struggle to properly cite Supreme Court cases, that reflects a problem." A quiet murmur spread among some members. It became clearer where the exchange might be heading. "That's helpful," Crockett replied calmly. "So, you believe your personal evaluation of legal ability carries more weight than that of state bar associations, the organizations responsible for licensing attorneys?" Levin leaned back slightly, appearing confident in his position. "Congresswoman, passing the bar exam is a basic requirement," he said. "It does not make someone a constitutional expert. I've likely forgotten more constitutional law than many attorneys will ever learn." At that point, Crockett shifted her approach. She reached for a thick folder and opened it carefully, allowing the cameras to capture the moment. "Mr. Levin," she said, "let's examine that perspective. You attended Temple University Law School, correct?" "Correct. Class of 1980, Levin answered. "And how many years did you practice law before moving into broadcasting?" Levin's expression tightened slightly. "I worked in the Reagan administration and in private practice for several years," he responded. "Understood," Crockett said evenly. "And when was the last time you personally argued a case in court? Not discussed one on air, but actually stood before a judge and presented a legal argument where someone's future depended on it?" The room became very quiet, with only the faint sound of cameras adjusting focus. Levin paused. "My experience in the Reagan administration," he began. Crockett interjected calmly, "I'm not referring to political roles, Mr. Levin. I'm asking about courtroom practice. When was the last time you filed a brief under pressure because a client's outcome depended on it? When did you last manage courtroom procedures where precision was critical?" "This line of questioning is unnecessary," Levin responded, his frustration becoming more visible. "My record speaks for itself. I've written several best-selling books on the Constitution." "Books?" Crockett replied, her tone steady and controlled, emphasizing the word with deliberate timing. "You've written books. I've defended lives in courtrooms. You've discussed the law on radio. I've applied it in practice. You've criticized others' education from behind a microphone. I've used mine to help keep innocent people from going to prison." She leaned forward slightly. "So tell me, Mr. Levin, and please give a direct answer, do you believe that decades of radio commentary make you more qualified to discuss the law than someone who has actually practiced it?" Levin's expression tightened, and his hands rested firmly on the table. "My record speaks for itself," he replied. "I've influenced legal thinking in this country in ways your record has not." Crockett opened her folder and began reviewing documents one by one. "Let's look at that record," she said. "On January 15th of this year, you stated on your show that Marbury versus Madison was fundamentally about judicial restraint. Would you like to revise that statement now, or should I explain to the committee why that interpretation is inaccurate?" A few legal observers in the room reacted quietly. Anyone with basic legal training knew that Marbury versus Madison established judicial review, not restraint. "That's taken out of context," Levin responded. "On February 22nd, Crockett continued without pause, you said the 14th Amendment's Equal Protection Clause was not intended to apply to voting rights. Would you like to reconsider that, or should I reference the 1866 congressional record?" Some members exchanged glances as the questioning continued. "On March 10th, she went on, you stated there is no constitutional basis for executive agencies to issue regulations. Are you familiar with Chevron versus Natural Resources Defense Council? I can cite it if needed." Each example was delivered clearly and without raised volume. These were not political disagreements but questions about established legal interpretations. Levin attempted to respond, raising his voice slightly. "This is an unfair setup," he said. Crockett responded calmly, You've spent years questioning the education and qualifications of others. You've suggested that some individuals succeed due to factors other than merit. I'm simply asking you to demonstrate the legal understanding you claim. If you're able to do so, this is your opportunity. The situation left little room for an easy response. Crockett adjusted her tone slightly, making her next question straightforward. Let's try something simpler. Can you explain the difference between a motion in limine and a motion for summary judgment? These are standard legal tools that practicing attorneys use regularly. Levin hesitated briefly. The terms were familiar, but the distinctions were not immediately clear in his response. Crockett continued, "All right. What is the standard for ineffective assistance of counsel under Strickland v. Washington? Many attorneys know this well because it directly affects their cases." The shift in the room was noticeable. The discussion had moved fully into technical legal knowledge. "You've spoken about participation trophies," Crockett continued, her tone still controlled. "But it's important to distinguish between discussing the law and practicing it. One involves commentary. The other involves real-world responsibility." She held up a printed transcript. "On April 5th, you said, 'These lawyers wouldn't last 5 minutes in a real legal debate with someone who understands the Constitution.' We've been here for some time now, and I'd like to give you the opportunity to address these questions clearly." The room grew louder briefly before order was restored. Crockett continued with a final question. "Mr. Levin, one more opportunity. Can you explain the doctrine of incorporation and how the Bill of Rights applies to the states through the 14th Amendment?" The question was fundamental to constitutional law. Levin began to respond but paused as he searched for a precise explanation. Crockett then clarified, "The doctrine of incorporation refers to the process by which the Bill of Rights, originally applied only to the federal government, has been extended to the states through the Due Process Clause of the 14th Amendment. This has occurred over time through Supreme Court decisions." She mentioned examples such as Gitlow v. New York and other key cases to illustrate the principle. The room remained quiet as she concluded her explanation. Crockett then presented her closing remarks. She held up documents for reference. "This is my law degree from the University of Houston Law Center," she said. "This is my bar certification in Texas. And these are examples of cases I've worked on and argued. My experience comes from active legal practice." She looked toward Levin. "The difference here is not about where we studied or our backgrounds. It comes down to current, practical experience with the law. That is what informs my perspective." She paused briefly. "When discussing the qualifications of others, it's important to rely on accurate understanding and direct experience." Levin attempted to respond, saying, "This is an unfair characterization." Crockett replied calmly, "This is a discussion about the difference between commentary and applied legal work. Both have value, but they are not the same." She then gathered her materials and concluded, "I have no further questions." The session moved forward, but the exchange left a clear impression. Levin remained quiet for a moment, while those in the room reflected on what had just taken place. A brief recess was called, giving members time to regroup. Crockett stood, adjusted her jacket, and exited the hearing room in a composed manner. She did not pause for reaction. Her approach remained consistent with her role throughout the exchange, focused, prepared, and grounded in her experience. As she passed, she briefly noted that she would be interested in hearing further discussion on the topic later, then continued on. Soon after, clips of the exchange began circulating widely. Commentary from different perspectives followed, with analysts discussing the legal points raised during the hearing. Some highlighted the importance of accuracy in legal discussions, while others focused on the contrast between theoretical commentary and practical experience. Media coverage expanded quickly. Reports summarized the key moments, and legal experts weighed in on the accuracy of the arguments presented. Some emphasized that the exchange underscored the importance of staying current with legal knowledge, especially when speaking publicly on complex issues. That evening, Levin addressed the situation on his program. He criticized the format of the questioning and described it as overly confrontational. However, he did not directly revisit the specific legal points that had been raised. This led to further discussion among listeners and commentators. Audience reactions varied. Some supporters defended Levin's broader contributions, while others raised questions about the specific issues highlighted during the hearing. Online discussions grew, with users reviewing past statements and comparing them with established legal interpretations. Media figures offered different perspectives. Some suggested the exchange reflected the challenges of discussing complex legal issues in public forums. Others viewed it as a reminder of the importance of precise knowledge when making authoritative claims. In the days that followed, the focus gradually shifted toward Jasmine Crockett. Her profile increased significantly, and she was invited to speak on legal and policy topics. Many noted her emphasis on preparation and applied experience as key factors in her performance. Law schools and legal organizations referenced the hearing as an example of effective questioning and the importance of clarity in legal reasoning. Discussions emerged about the balance between academic knowledge, public commentary, and real-world legal practice. Professional organizations highlighted the value of maintaining up-to-date expertise. Some institutions encouraged ongoing education for those who speak publicly on legal matters, reinforcing the importance of accuracy and responsibility. Crockett addressed the attention in subsequent interviews. She explained that her goal was not personal criticism but to highlight the importance of respecting professional expertise. She emphasized that legal work involves real consequences and requires continuous learning and application. Her remarks resonated with many in the legal community. She spoke about the responsibility that comes with representing clients and the need for careful, informed analysis. Her message focused on the distinction between discussing the law and practicing it in real situations. Over time, the hearing came to be viewed as a broader example of how preparation and subject knowledge can shape public discussions. It also contributed to ongoing conversations about expertise, credibility, and accountability in media and politics. As her career progressed, Crockett continued to build a reputation based on her legal background and legislative work. She remained active in discussions about justice and policy, often emphasizing practical understanding alongside theoretical knowledge. The impact of the exchange extended beyond the individuals involved. It encouraged more careful engagement with legal topics across media and political platforms. Commentators increasingly supported their arguments with clear references, while audiences became more attentive to accuracy. In legal education, the moment was sometimes used to illustrate effective questioning techniques and the importance of preparation. Students examined how clear, structured inquiries can reveal strengths and weaknesses in an argument. The broader takeaway centered on a simple idea: expertise is strengthened through consistent practice, study, and accountability. Public discussions benefit when participants rely on accurate information and direct experience. Years later, the exchange was still referenced as an example of how informed questioning can shape a conversation. It highlighted the value of preparation, the importance of clarity, and the role of professional experience in understanding complex subjects. Crockett's approach remained consistent throughout, focused on facts, grounded in experience, and presented with composure. Her work continued to reflect those principles, contributing to her standing as a knowledgeable voice in legal and policy discussions. As she addressed the justices, observers reflected on her steady rise, from a modest law school to Congress, and now to the nation's highest court. For many, her earlier exchange with Mark Levin marked an early turning point. It drew attention to how experience and preparation can shape public understanding of legal expertise. As she spoke with clarity and confidence, carefully citing precedents, those in attendance were reminded of that congressional hearing years earlier. It was a moment when a prepared attorney challenged widely held assumptions and highlighted the difference between discussing the law and applying it in practice. In the years that followed, Levin's public presence became more limited. His programs changed direction and his audience shifted. His trajectory was often referenced in media and academic discussions as an example of how public credibility can evolve over time, especially in fields that require up-to-date knowledge and precision. At the same time, the broader takeaway extended beyond any one individual. The moment reinforced the idea that, in an era of constant information, credibility is closely tied to accuracy, consistency, and real-world experience. It also showed that established narratives can be reassessed when challenged with clear facts and careful reasoning. As Jasmine Crockett concluded her argument before the court, the gallery responded with rare applause. She reflected briefly on the earlier hearing, the moment she chose to question assumptions about authority and expertise. That exchange had not simply been about one discussion. It contributed to a wider conversation about how knowledge is demonstrated and evaluated. Her approach emphasized preparation, subject knowledge, and practical experience. These qualities continued to shape how audiences viewed expertise in legal and political discussions. The contrast between presentation and practice became a recurring theme in commentary that followed. In discussions about expertise, one idea stood out: clear understanding, supported by evidence and experience, tends to carry lasting influence. Public conversations benefit when participants rely on accurate information and thoughtful analysis rather than volume or repetition. Jasmine Crockett's role in that shift was widely noted. Her method, focused on facts, steady questioning, and applied knowledge, became a reference point in both legal education and public discourse. It illustrated how preparation and clarity can guide complex conversations. By the end of the moment, it was clear that the discussion had moved beyond a single exchange. It had become part of a larger reflection on how authority is defined and how expertise is demonstrated in modern society. If you followed the full story, you've seen a detailed example of how preparation and knowledge can influence important discussions. This was not only about a disagreement between two individuals. It also highlighted how standards of credibility can evolve. For more in-depth stories and thoughtful analysis, stay connected with the channel. Share your perspective in the comments. How do you view the role of expertise in public discussions today?